Hello, my name is James Kemp. I'm a member of Trinity Chambers and I predominantly practice in the field of contentious probate. And this is a short webinar discussing the various issues that have arisen as a result of the unfortunate COVID-19 pandemic and the effect on probate itself. A number of issues have been thrown up by this, which I shall briefly discuss through this webinar. But this is not going to be a trawl through contentious probate discussing the usual issues that arise, but has, as the title suggests, a COVID-19 angle. There has obviously been an increase in probate work that's been reported in the press and also in the local journals. And a number of issues, as I say, have arisen. Predominantly, the first is in relation to the execution of wills, and a lot has been made about this. I recently shared a article written by Stepp, upon which I'm a member, on LinkedIn, discussing what the government intends to do by the complications that have been thrown up by the Wills Act of 1837, where, of course, a will has to be witnessed in the presence of, and that's section 9. Now, bearing in mind the issue with regards to lockdown, isolation, and shielding, that has proved to be complicated, to say the least. And no doubt, the bright sparks amongst us have thought about witnessing wills by video. The question, of course, is whether this would satisfy the term, as I've just said, in the presence of, in a Wills Act that was enacted in 1837, which quite clearly the draftsman would not have had in mind the issues that now face us in the modern world. There is at present no decided case on the matter, and through the industry obviously raising some questions and alarm over this, the Ministry of Justice has announced that they will issue a statutory instrument, to get technical, under the Electronic Communication Act 2000, hopefully to be issued in this month, that is September, which witnessing by video will be deemed to be sufficient for the purposes of the aforementioned Wills Act. That will be retrospective from the 31st of January this year, but also at present it may have a sunset clause, and therefore the statutory instrument will effectively deemed not to be applicable as of the 31st of January 2022. So practitioners need to have in mind that when executing any wills. Of course, the legislation hasn't been published yet, and therefore, in some respect, the guidance that I will now be referring to is somewhat in the dark in that regard. But in this respect, those who are members of Stepp will have seen that they too have issued guidance along with publications in the Law Gazette, and also the government themselves have issued guidance on their website. What I have is I have a slide with regards to the web links for certainly the government and the Gazette. And along with Stepp, all these are suggested to be read in conjunction with each other. It's unfortunate that they can't have one form of guidance, but nonetheless, when you read it, you will see that it broadly reflects exactly the same issues and dealing with the same. I have in front of me the Stepp Guidance, which I have to say is the most thorough of the three. And for those of you that are members can access it through the website. Again, as I say, there has to be a note of caution that determination of what exactly is going to be said in the legislation is not yet available. However, it does, for those of you that have to and are involved in executions of will, deemed useful in undertaking that task, not only to protect your client, but also, as I say, yourselves perhaps when issuing it. Stepp Guidance gives an introduction as to the video, but also, as I say, the guidance about video witnessing. In other words, that even if all parties appear by video link, that it's important that quite clearly the witnesses have a clear line of sight of each other, and see signatures being made, and also what the document actually contends. In fact, all guidance usefully provides bullet points and also various stages that the practitioner should look at when actually being involved in executing a will in this era. Just as a matter of precaution, you may, if you wish, record it and store it, subject to obviously the consent and the compliance with various data protection rules. But of course, no pre-recording can take place. That is not advised. It all has to be done live. But there is issues that may arise in respect of execution by video. These are such issues in respect of undue influence, fraud, and duress, because of course not everyone can see who is present within the room when such execution takes place. And the guidance that I referred to gives suggestions as to how to deal with that. And I suggest that consideration is taken of that quite carefully, and also detailed attendance notes, which I'm sure you're alive to, certainly to protect yourselves if you are participating or witnessing such execution. So there we go with regards to wills. I highly suggest, certainly if you can get access to the Stepp Guidance, that you do, but nonetheless the government guidance and the Law Gazette have published equally detailed guidance, for want of that phrase again, to assist practitioners. The next issue I want to touch on is, of course, testamentary capacity. COVID-19 has raised a number of medical issues that perhaps weren't prevalent before, and one can see that there are issues certainly in respect of the fact that it is a respiratory disease, and therefore that may raise the issue of hypoxia, which of course can cause confusion. There was also the issue of the fear of impending death, perhaps, not to mention the self-isolation that a number of vulnerable people are having to deal with as lockdown continues in some areas, but hopefully will be lifting, in addition to, of course, shielding. All these, of course, may raise an issue of testamentary capacity. Those who operate within the field of contentious probate will also be aware that grieving for the death of a close one or loved one can also raise the issue of testamentary capacity. So practitioners in this field might well be wise to consider these issues that have arisen, bearing in mind the symptoms that COVID-19 causes. There is the case of Sharp and Adam that the High Court gave useful guidance with regards to what a practitioner should include in the will for a testator to sign when executing it, that would both protect them and also advise their client in executing the will if, as I say, capacity is unsure. I'm not going to reiterate it. It is worth a read for those who are dealing with, as I say, clients upon which there is doubt as to whether capacity exists, or medical professionals can't confirm the same, obviously following the golden rule. I've mentioned this briefly before, and that of course is undue influence. Video recording is more susceptible to such influence, and practitioners certainly should be more alive to this than perhaps ever before. But also there's the issue of self-isolation. That, in respect of the vulnerable, can make them even more vulnerable to those around them. And again, practitioners no doubt will be alive to that situation as well. One other and final issue that has cropped up is, of course, Inheritance Act claims have increased, and certainly with regards to adult claimants. This is nothing new, of course. Ireland Ibbotson dealt with it. But there's a recent case, which I'm afraid is unreported, at Shapton v. Seviour, which the High Court deals with adult claimants, and the fact in this case they were being too optimistic in their claim, and the fact that those who are on the receiving end of such a claim should not be almost pressurized into trying to settle it if they feel that they have a good stance. And as I say, the adult claimant is being too optimistic. I've touched very briefly on the issues that have arisen. I've given you, I would suggest, guidance as to where to look and what to consider in this COVID-19 era. And hopefully you found this useful. Thank you very much.